public trustee in Australia, and they wanted me to name the assets, and obviously they want you to update the will if it changes.
Yeah, it's a bit naughty, isn't it?
But it doesn't cost anything.
Oh, well, that's good. Okay.
It does when you die.
But when you die, it does.
It costs you a bloody fortune.
Yeah.
I would never go to the public trustee in Australia.
Or you get them to write the will and then you go and do another one after. Yeah.
You ever seen the percentage they take when you pass away? Horrendous. Not worth it.
Yeah, I mean, and actually in Thailand, you quite often see the Thai wills which like to name the assets, which is okay, but as long as there's a clause to say, and any other assets acquired after the date of the will, because otherwise those assets are potentially not covered. So by having a definition of my estate in the will is fine. You should of course have a list, I think separately, but stored with the wills, which you update regularly to make sure that it's accurate and in place. So I wouldn't, unless there's a specific gift of a property or a bank account, I don't think you need to name the assets in the will itself.
What's your treatment of digital assets?
Oh, good question. Yes, gosh. I went to a seminar in the UK last year about digital assets. You can appoint a digital executor in your will now, and you can give somebody authority over your digital affairs. And so that's probably a good idea. Ultimately though, those assets, your email, your Facebook, your LinkedIn, your secret online betting account that we came across the other day, the succession of all of those are really governed by the terms and conditions. There's a smile at the back there, secret betting account, yes. But they're all governed by the terms and conditions of when you set those up as to what happens. So again, on your list of assets, it's not just the property, the bank accounts, the investments, and your liabilities. It is all these other things, your emails, your passwords, the safety deposit box, all club memberships, the list goes on and on and on. And so, yeah, it's important to make adequate provisions for those. And you can do that more and more in wills.
So, under which country would, stocks or cryptocurrencies or whatever fall legally?
Well, the answer is where those assets are deemed to be domiciled. And so a lot of people have got, platforms in Singapore, and the platform invests money in all sorts of places around the world. So the question for the wealth advisor or the financial planner is, if you die, where is probate required? Probate hopefully isn't required in the half a dozen countries that the money's invested in. It should be required in the place where the funds are domiciled. And so, again, understanding the location of the assets is important, so that you've got a will to cover that place, basically.
I've heard that I've got property in Australia and here.
Yeah.
You need 2 wills.
That's the general recommendation. Yeah.
Maybe, all right. I've got this property here on my Australian will, but they reckon they don't recognise it here.
Yeah, generally speaking, if you've written a will in Australia, and it's written in accordance with your nationality or where the will was written, that's of course a valid will. That will...
In Australia?
In Australia,
right.
But in most countries, not all countries, but in most countries, that will would eventually be accepted once the probate process has been complete in Australia. So if it's written in a valid way, it's usually accepted in most other countries. But for the delays and the time frame and everything else,
it needs to be written in Thai.
It doesn't need to be written in Thai. No. As long as it's in a language you understand, it's fine. But if you can imagine, if you die, you've got a Thai will, you've got an Australian will, your executors are happy because they're doing that probate simultaneously. They're sorting out Australia at the same time as the Thai will, written in accordance with the laws here. Your executors are just going to be able to deal with everything far more quicker, cheaper.
Are you supposed to have 1 last will, not 2 last wills?
Yeah.
I think a joint account is the best.
For this one, actually, you also can recognize the Australian will as well. So it means under Thai law, yes, if you're going to do only the Australian will, but then in Thailand, they can accept the Australian will, but in some clause, they not accept it, example for the trustee. However, you also can recognize on the Thai will to say you have an Australian will, to at least recognize it, but you did not revoke it. Because otherwise, your last will be revoked the previous one.
That's right, you're right. Your last will, it's supposed to be your last will, and then you make another one. When you make another will, the old will is revoked, and so on and so forth. And so
They can't have two wills.
you can have two wills. Then, as the lady at the back says, it's important to understand that the jurisdictional coverage of the wills is correct, and that the wills don't revoke each other. So it's perfectly fine and possible to have, we've written 11 wills for clients, and as long as they're specific for the countries and they don't overlap and revoke each other, it's perfectly fine.
Can you have this is my last will and testament in Thailand, this is my last will and testament for the rest of the world, can you do that?
You can, and I think it moves on nicely here to how many wills you should have. Is your will valid in other countries or domicile? The structure of the wills is determined by somebody's domicile. And so if somebody's domiciled here, you don't have just a Thai will, you should have a general will. You would then have a country-specific will for the other places where you have assets. So your worldwide movable assets are governed by your will of domicile. And then you say, well, what's domicile? And I'll talk a bit about that in a minute. But essentially, yes, what you don't have, you shouldn't have an Australian will and a Thai will, because next year when you open a bank account in Singapore, that money won't be covered by the two wills. So one of those two wills should be your global catch-all main will, and that would usually be the will for the country that you're domiciled.
But not necessarily. I mean, I assume most people here would come from UK, and I'm from Australia. I mean, our main will would be in UK or Australia, even though we're all domiciled here.
Definition of domicile.
Sorry?
The definition of domicile.
Yes.
You're not domiciled just because you're living here, you're domiciled by
Correct.
election of the government.
Correct. No, it's certainly for Australians it's less relevant because there's no estate tax in Australia. There's plenty of other taxes, but there's no estate tax. For Brits living in Thailand, living in Hong Kong, Singapore, wherever, the domicile is critical, not only for the structure of the wills, but also for how your estate would be taxed after you've died. So if you've got somebody from the UK living in Thailand, in all of their wills, there should be a clear statement that they consider themselves, if they do, consider themselves domiciled in Thailand. If they are domiciled in Thailand, that Thai will should be a main general will, and you have country-specific wills for the other places. So definition of domicile, your domicile is your choice of country that you consider your home now and for the foreseeable future, and where you ultimately plan to retire and die. So some people think, gee, I've got no idea. Some people say, well, I've been here 20 years, I'm going to stay in Thailand. The problem with domicile, and if I take a step back, the reason the domicile is important is for UK, domicile is really only relevant for people from the UK for tax purposes. Take me as an example. I was born in the UK, grew up there, and 16 years ago I moved to Hong Kong. And I've stayed in Hong Kong for 16 years. So my domicile of origin was the UK, where my father was born. So I acquired at birth my UK domicile of origin from my father. Now, having grown up in the UK and left and moved to Hong Kong and spent 16 years there, everybody has a domicile of choice. You can choose where you consider your new home and your domicile to be.
Until they kick you out.
Until they kick you out, yeah, they might kick you out. Then you've got problems.
So it's never permanent. Your domicile is actually England. You can live in Hong Kong, I can live here. But
Well, no, 'cause I mean,
you come tomorrow and cancel my visa, I've got to get out.
Perhaps in Thailand, I mean in Hong Kong I've got a permanent ID now.
Okay,
So
you've got a permanent resident visa.
you've got perhaps more, I know what you mean. You've got,
Yeah, you can get that.
Yeah.
Until you kick that, you don't.
It's always,
But there might
domicile is always
be
tenuous.
that problem. Yeah.
Domicile's
Does it
always
really
tenuous.
matter? Does it really matter if you have a will that's valid for the country in which you live and then you also do ones for other countries? Does it really matter what the main domicile is?
It does.
Yes, because
Like it does with England, yeah.
your
Very much so,
main
very
domicile will should be for the country where you are in fact domiciled. So for example, we have a lot of people who come to see us and they've written a will in England. They've just written my last will and testament. Then they move to Hong Kong or to Thailand or Singapore or whatever. They say, right, we need to add on a will for Hong Kong now. Well, if we simply add on a will for Hong Kong only, that doesn't fit in with the correct structure of how those wills should be written. When people come in with no wills and they're saying they're domiciled in Hong Kong, that main will is for Hong Kong and it's your domicile will. You have a separate will for the other countries. So it's important to have them written in that way for tax purposes. So the reason it's important, which people often don't realise, if, say, I die in Hong Kong and say I haven't written a will and there's no mention of my domicile, the UK tax authorities might say, well, I'm British, got a UK passport, I'm still domiciled in the UK. Yes, I'm resident in Hong Kong, but I can still be deemed to be UK domiciled. That's important because if I was deemed to be UK domiciled, and I don't find out until I've died, and I'm dead, so I can't argue with anyone, then the UK 40% inheritance tax would then apply to my worldwide assets. If I'm successful in saying I'm domiciled in Hong Kong, and I've written a will, and I've stated in the will that I'm domiciled in Hong Kong, if that's successful, I would only pay UK inheritance tax on my assets in the UK, above a certain allowance, which at the moment is only £325,000. So
it excludes your primary residence, doesn't it, if you've got a UK?
there's been a slight change, hasn't there, recently, where you might have seen the headlines that the allowance is going up to £1 million, that sort of thing. At the moment it's 325,000, it's increasing a little bit, up to potentially £500,000 each for a married couple or civil partnership. So there's no tax between married couples or people in civil partnerships, so the tax only usually applies in the UK when both people pass away. So at the moment it's 325 plus 325, so it's 650. In a few years, if you have a qualifying property or residence, you can get a slightly larger allowance.
Does that apply in terms of property ownership in the UK if your partner is not British?
Yeah, good question. Generally speaking, if you've got husband and wife both from the UK, there's no tax between husband and wife of the same domicile. If you have somebody from the UK with a foreign spouse, a few years ago there was a potential tax on what we call first death. So I die, my wife is not from the UK. The worry is that I die, give all my money to my foreign spouse. When she dies 5 years later, she's got no obligation to pay tax in the UK. So they wanted to tax the British person when they die, if the spouse is foreign. The tax treatment was a little bit different. They used to get a lower allowance. They've changed that in the last few years so that there's still no tax to pay between a husband and wife, but there's a few provisions that the surviving foreign spouse would have to go through to defer that tax until after they've died. Is the rough answer. Yep.
Could you comment on the Thai attitude to domicile? Is there any situation in which the Thai authorities would go after assets of people who live in Thailand, but those assets are not in Thailand, say they're in the UK?
Yeah, that's a good question. So a couple of years ago, Thailand introduced an inheritance tax.
Yeah.
It's only 5%, and you get, I think it's 100 million baht as a tax-free allowance, so it's fairly generous. I did a will for a guy here a couple of years ago, and he sought specific tax advice for exactly that question, because he was worried that he was claiming domicile here, and he wasn't a Brit, he was an Australian guy actually, and he was worried that if he claimed domicile in Thailand, that the 5% tax here would then extend to his worldwide assets.
Now you have to be a permanent resident to apply for that. So if you're for example, I'm Australian and I'm a tax resident here. I've been here 12 years. My domicile, unlike UK, where you have domicile of origin, domicile of choice, my domicile under Australian tax law and under Thai tax law is where I live. So I'm domiciled here. But I don't have to worry about inheritance tax if my assets are overseas. Unless I'm a PR or have national citizenship.
That's right. So this guy's tax advisor came back with that answer. They said his assets in Thailand would be taxed if they were above the tax-free allowance at 5%, but there was no danger of his worldwide assets falling under the Thai jurisdiction, is my understanding.
Even if he has permanent residence in
Now
Thailand?
that's a bit different. Permanent residence can change things. If you've got PR, it may change. You may be caught on the PR. That's another reason.
So then they would be taxed in the home country.
No. No, it may come under Thailand in the future. You know,
But no, but I mean, if you're a resident here, but not a permanent resident,
yes,
you're
then you don't have to worry about overseas assets at all.
here, but would they be taxed in Australia?
Not at all, because we don't have inheritance tax in Australia at all.
But would they be taxed in the UK? Yeah.
So yeah,
Well,
again,
if
so
it-
if you were deemed to be UK domicile, then yes, the 40% tax then extends to worldwide assets.
But if it's the other way around, so if you're Thai domicile, you have assets in Thailand, they fall under the Thai law as inheritance tax. But if you have assets in another country, they fall under that country's inheritance tax.
But
Yeah, so
obviously from UK tax planning, sorry, this is my area of taxation. Obviously from a UK tax planning point of view, you would like to choose a domicile in Thailand. I mean, to overcome
Yeah, of
inheritance
course,
tax,
it's
because
preferably
they
domicile
is
here.
all exempt to your
UK.
spouse. It doesn't matter if it's above.
Well, yeah, I'm not from the UK, so I'm just thinking in general, is there always tax over your assets somewhere or not?
It depends. So it depends. You can be taxed on for estate or inheritance tax either on your nationality or on the location of the assets. So as an example, we have a lot of clients who've invested in the US, but they're non-Americans. And they don't realise, and the UK would be the same, if you've got an Australian, if you go and buy a house in the UK for £1 million and you die, your £1 million property in the UK is subject to UK inheritance tax. Even if you've never been there, never lived in it, and you've got no intention of going there, because it's an asset in a country with tax, it's subject to the local taxes. So a lot of people don't realise that, and the reason I say the US, for Americans, so if you're an American citizen, you're taxed on worldwide assets while you're alive, you're also taxed on worldwide assets if you die. At the moment, Americans get a very large tax-free allowance, it's about $11 million US. But for foreigners, if anybody here is non-American, but they've got assets in the US and they die, those assets are subject to US estate tax at 40%. You don't get the $11 million allowance, you only get $60,000. So we have a lot of clients who come in, they've bought a house, they've got investments in the US, not realising that if they die, those assets are also subject to taxes. So your assets can be taxed in a variety of ways, basically. Yep.
When do those taxes get paid? Before or after probate is granted?
As part, it depends in different countries, I think. It's part of the probate process. Normally, executors can't distribute assets from an estate until taxes have been paid off, along with any other debts.
And where does that money come from?
Well, good question. It comes from the estate if they've got access to it. There are plenty of occasions where the main asset is the family home and there's no liquid cash to pay off the tax, so executors can take out personal loans to pay off tax and claim the money back. Sometimes property has to be sold in order to pay off the tax bill. So.
But did I understand correctly that even if you are subject to taxes on death taxes on foreign assets because you live in Thailand and are classed as domicile, even if that happens, you're only going to be taxed on assets above 100 million? Did you say 100 million
Yes,
baht?
that's the...
And even above 100 million baht, it's only 5%.
Correct.
And that's
Which is
only to children or other ones. If it's to your wife, it's totally exempt. You can have 500 million and give it to your wife, it's totally exempt.
Very good.
Right, okay, so it's compared with the 40% that you're quoting for Britain and
Yes.
the US. It's not terribly serious.
It's not. So, of course, so for Brits, long-term Brits living in Thailand,
Yeah.
far better for them to be domiciled here than to be still deemed UK domiciled.
Same subject, just to clarify. I've been here for 23 years on one-year visas. Would the UK accept me as being domiciled in Thailand?
Good question. I was trying to just recall the country that there was a case. It was somewhere in Africa, and this guy is in the same situation. He'd been on one-year renewable contracts for a period of time, and he claimed domicile in that country, and he died claiming domicile of that place. And he'd gone to a court.
But you lost, yeah, no, it's crazy.
Right to Lord Rothermere, if you know that case.
Well, hang on, did he? He lost.
He lost it, he lost.
Well, the one I'm thinking of, the case was successful that he had the foreign domicile. on this one-year renewable
I
visa?
don't know which one it was, but
Okay, well that might have been a different one. I can't recall the country, but
Well,
there was a case where it was successful.
There's a case I know of where the guy was trying to claim non-domicile in the UK, living overseas for many years, and he kept a plot for his grave.
Yep.
He was considered to be domiciled.
that was great talking about that one.
Is it?
Yeah, that's-
Very harsh.
Okay,
The laws in
yeah.
England are very harsh.
that's the same.
You're right. So, as I said, the final question we ask people for wills is where do you want to be buried or cremated? For clients that we see in Hong Kong, we ask the question and we answer it immediately on behalf of the client. We say you have to be buried or cremated in Hong Kong. So they don't be buried in Hong Kong. But you're right, if you write a will, and if you're from the UK, and if you say in the will, I'd like to be buried in England, cremated and scattered in England, in the UK, you're automatically UK domiciled, and there is case law in the UK to that effect. So they will look at those types of things to get the tax.
Related to that, I came across a situation recently where a guy bought a chunk of land in this country. And you know that you can't own land in this country, so he put it through a company. And then he put a back-to-back BVI, British Virgin Islands. And now all the transactions that occur are outside Thailand because you just move stuff through the BVI system. What are your thoughts on that? Does that work?
To avoid tax?
Yep.
Yeah, maybe. For many years in the UK, people would own their UK property. So the Australian guy here is going to buy a property. You don't want to buy it in your name because if you die, it's 40% tax. You open your BVI company or your Hong Kong company or Cayman Island company, and the company purchases the UK property. So if you die, you don't own the UK property, you own shares in a BVI company where there's no inheritance tax. So for many years, that was a perfectly legitimate way of avoiding the UK inheritance tax.
10-year one, haven't they?
Well, they've clamped down on that completely. So there's no benefit in owning UK assets through a trust or through foreign companies. So they've really clamped down on that to a point where you might as well just buy it in your own personal name. For other countries, there are still benefits. I know in the US you can do that. You can buy assets through a foreign company, provided it's structured in the right way, and you have to be very careful on anything with US connections. And Japan is another one we come across a lot. People have investment properties, holiday homes in Japan. They'll quite often buy those assets through the BVI company for the same reason. Japan has one of the highest taxes for foreigners, inheritance taxes. So if you buy the ski chalet through your offshore company, you can still avoid some of the taxes. Again, the answer generally to all of that is if you're thinking of buying property in any country, think about the taxes, get specialist advice as to how you should own the property, whether you should buy it in your name, in your partner's name, through a trust, through a company, and understand the pros and cons, I suppose. Not just for inheritance tax, but also for capital gains tax, stamp duty, income tax, and all those other relevant parts, I guess. Yeah.
Going back again to my personal thing about domicile. If you're accepted in the UK as a non-resident for tax purposes, does that would that help you, say you're domiciled in Thailand? Or is that a completely different thing?
It's for many years it's always been quite different, but there's more similarities, or it's more connected these days. It's always easy to show where somebody is resident and where they've been resident. Because you're resident in one place, it doesn't mean that you're domiciled there. You can still be domiciled in another country. So again, in the last year or two, there's been significant changes to the UK statutory residency test. So somebody like myself, if I started spending 2 or 3 months a year in the UK, I'm still resident in Hong Kong, but I might, by mistake, become resident in the UK. I would then regain my UK domicile, and I'd be subject to 40% tax. So it's becoming more connected, so you have to be careful with all of that.
I just ask that when we live and die in Thailand and we have assets in another country, maybe not even the UK, maybe in Asia, is it a good idea to get the will certified by the embassy of that country, or have a notary public certify it so that it would become more acceptable, or does it not matter?
No, in some countries it's beneficial to have a will notarised. The US is one, but as long as the will's been signed and is formally valid, having a lawyer or an embassy stamp it or chop it is of no use.
Oh.
We've seen people try and do that, and the embassy makes a mess of it, and they don't put the date on it. So it's not usually required.
So the two witnesses are much more important then.
If it just needs to be signed with two witnesses and they witness in your presence, and that's a valid will, that's a valid will. There's no benefit in having any other signatures or notarisations on the document.
Okay, good, thanks.
What if the witnesses don't survive you?
If what, sorry?
What if the witnesses don't survive you?
Oh yeah, gosh. Well, the witnesses are only required if you die and then there's a problem with the will. Generally speaking, one of the witnesses is usually called upon to the court to swear an affidavit to say the will was signed and witnessed correctly to make sure it was a valid document. So when the courts have satisfied themselves that it's a valid document, they can then proceed with whatever the challenge is. If both witnesses have died or can't be contacted, then I think the court just has to use some judgment and discretion as to whether it appears on the face of it the document constitutes a valid will.
So in that case, if you're stating that you're domiciled in Thailand, is it better that one of the witnesses is a Thai national?
Not necessarily, no. I think, for the wills that we do for clients here, myself and a colleague are the two witnesses. When our staff leave, we keep contact details of previous staff who have witnessed wills so that if required, they can be contacted. I signed a will yesterday though, and they got the neighbour in to sign the will. They're a long-term friend, and that's fine, but we'll keep contact details of those people. Generally speaking, it's only one of the witnesses that is called upon for that process. Okay, let's go through a bit more of this. We're nearly done. So we talked a bit about this already, perhaps we haven't, living wills. Somebody was saying earlier that in their will, somebody had written that they didn't want to be kept alive if they were in a coma on a life support machine. They put that in the will. The problem with that, the will only takes effect after you have died. So if you want your wishes for end-of-life medical treatment to be known, that should go in a living will or an advanced medical directive. So for clients who've got strong thoughts about that, you can make a living will. Now they're quite common in Thailand, and it's advisable that a family member witnesses a living will apparently. So you can make a living will, and what people often assume is that husband, wife, spouse, adult children could actually tell the doctors what your wishes would have been. In a lot of countries that doesn't happen. Doctors won't follow wishes of next of kin. They'll kind of keep you alive, keep you going for as long as they can. That's often not what people would have wanted. So for those people with strong feelings, you can write a living will. The other one is to do with your financial affairs if you become mentally incapacitated. So not that you're in a coma and you're going to die in a week, but you've had an accident or you've got Alzheimer's later in life and you're not able to manage and handle your financial affairs. So if that's the case, for some people, all the assets are in one person's name for whatever reason. So if that person became incapacitated, it's a problem for the other. So again, in a lot of countries, you can do an enduring or a lasting power of attorney. That's a document that you can appoint somebody to access your bank accounts, pay the bills, pay the medical fees, the mortgages, the rents, household expenses, until such time as you might recover and everything goes back to normal. If you eventually die, the will then takes effect. So those are a bit like wills. They tend to be required for the country where the assets are located. And some places have quite specific requirements for those.
So an enduring power of attorney made in Australia wouldn't be any good here?
I'm not sure. I think, you always want to check. I haven't come across an enduring power of attorney or equivalent in Thailand.
You've got a living will, that's all we've got.
How about,
certainly living will, yeah.
How about an Australian one? Would that be valid in the UK?
As you might know, Australian ones are state specific. I would think, the recommendation would always be if you've got bank accounts in Australia, bank accounts in Hong Kong, in the UK, you should have a separate document to deal with those assets if you're incapacitated. Most people would think they probably need one of those documents, and it's normally required where most of the main daily banking is. So that if you're incapacitated, somebody left behind can access the bank account so that they can keep things going for a few months. You often don't really need them in 2 or 3 or 4 different places. What else have we got? Did you know marriage can revoke your wills? Yeah, marriage, we have a lot of people come in, they've written a will and they say, well, we got married, and marriage has revoked the wills, which people don't realise. The beneficiary should not witness a will. We have a few people who try and sign their own wills, and husband and wives witness each other's wills and they're not valid. Yeah.
So that first point, you said getting married revokes the will, so then what happens?
Divorce.
Yeah, well, no, of course, I don't understand. So you have to create a new will?
Yeah, so if you've written a will, and then any time in the future you get married, legally in a lot of countries, not all, but most countries, marriage would just cancel your will and it's null and void. So yes, you'd have to then rewrite the will.
So what's the purpose of cancelling it?
It's just that it's just a legal provision. In most countries, there's provisions to say if you've got a will and then you get married, marriage would revoke the will. I think the idea is if I had a will before I was married, giving everything to my mum, I've now got married, I've now got certain legal obligations to my wife. And so it would naturally be a time that you would probably want to change your will to make provisions for those people who are perhaps dependent on you or who would have a claim on your estate, if you passed away and you didn't include them.
When you get married, get divorced, get remarried, you've got to have a new will for it every time.
That's it.
So
if I could
the
just come back
situation
to what
changes.
Howard said, the rule in English law about marriage revoking a will automatically, frankly, it's one of the most stupid rules in English law there is. The rule should be that divorce automatically revokes a will, and that's not the case in English law. Thai law actually takes the most sensible provision that either marriage or divorce does not affect a will, and it's up to you to take advice and make a new will in accordance with your new family circumstances.
Exactly, yeah. And, as I say, we do remind clients to update their wills accordingly. If we store wills for most people, we write letters to them every year to remind them if anything major has happened, get in touch. And there's often calls to say, well, we're not divorced, but we're separating. And so before we're legally divorced, we want to change the wills fairly quickly. So yes, keeping them up to date.
But doesn't a wife, when you get married, have an automatic right to your assets, even if the will doesn't say that?
Yeah, well, so yes, in some cases. So if you have a will, people come in and they don't want to give anything to the husband or wife sometimes. They want to leave it to children or other people. And we always make them aware that the general rule, and it's really a general rule, if you write a will, if I wrote a will giving 80% of my assets to my son and only 20 to my wife, if I died, she would be able to make a claim on my will. The way that the courts would treat that claim typically is they would distribute the assets in the same way as if we got divorced rather than me dying. And as a starting point, roughly she'd be entitled to 50% of my estate. So if my wife didn't benefit with 50% of my estate, she'd probably be entitled to more. And there are different laws in different countries which protect dependents for those types of claims.
There are ways to protect that too, so you could give her like an income while you're alive, but the assets go to the son.
Yeah, you can do life interests, that sort of thing too. But again, people could still claim, they say, well, I'm not happy with this monthly income, they want some of the capital. But yeah, there are different ways to protect and preserve assets through wills and succession planning.
Excuse me, you said Thailand has civil code. In that case, would that first line still be valid over here?
According to Steve at the back, then marriage and divorce has no effect on wills in Thailand. That's often the case in most civil code countries. A lot of Europe, marriage has no effect on a will. In a lot of common law countries, marriage would often revoke a will.
Yeah. Married, divorced, have children. Well, in Australia, always you have to make a new will.
Well, it's any of those major events. You should always at least revise the wills and look at the wills and make sure they're accurate.
Right, that's common sense.
Yeah. Signatory rights, supplementary credit cards. This is a bit like the joint accounts. My wife has got a supplementary credit card. That's fine while we're both alive. If I die, the credit card is cancelled and her supplementary credit card is no longer valid. And so again, that's a problem. A few things that we don't do. We don't usually name young children in the will because if more kids come along, you don't want to have to change the will. So we normally have a definition of my children. As we've said, we don't list assets in the wills. And usually we're not particularly interested in the complete value of somebody's estates for wills. It's more to know the locations and ownerships of the assets. Sometimes good to know what the value of estates are in countries where there is tax issues because you can write wills more tax efficiently. Questions and answers? It's 5 to 8. Yeah.
So you're talking about different wills for different countries.
Yes.
Why can't it just be the same document with a different paragraph for a different country?
Well, you can do. Yeah, if you want to do that, you can.
I just know your fees, so I thought it would be a better idea.
Yeah, you know, quite often the content of the wills, the appointments, the distribution is probably mirrored across 2 or 3 or 4 jurisdictions. The difficulty with that is the jurisdictional coverage of the wills and making sure that they don't revoke each other. And so that's what you're really paying for, I suppose, and the advice related to those countries. So it's not just a case of, here's your will, oh, I'll just photocopy this one and just write in Thailand, and now I've got a Thai will. It's not as simple as that, as you might imagine.
What is the position of the Thai authorities if another government comes to them after somebody dies in Thailand and says, we want that, we want those assets?
For tax
this
purposes, you
person
mean?
is, what is the attitude of the Thai authorities? Do they give in immediately? Do they spend the whole value of the estate on legal fees? What happens?
Do you mean if maybe there's a distribution from another will that says I give
another country comes and they said this person has domicile in Britain or in another country. We're entitled to death duties on this estate.
I see.
And they go to the Thai government. What happens? What's the position?
Again, take the UK as an example, or Americans have to pay tax on their worldwide assets. So where there's a tax treaty between the 2 countries, the tax wouldn't be duplicated, it would be offset. So in America they pay the 40% tax, the Thais still get their 5% probably, but it's offset so it's not duplicated where there's a tax treatment.
But that only applies to income tax, not inheritance tax.
I'm not sure. So I think that if you've got a very specific question on that, then it's a question for the tax
tax treaty only is income tax.
So what happens in the case of death?
That I don't know.
Okay. All right.
Yeah.
Are there any countries that are a no-no? You mentioned British Virgin Islands before. I've got a company that's structured in there. Is British Virgin Islands okay, or?
I'm not saying BVI is a no-no to have a company and to have a business interest. It's just that in places like the UK, there's no benefit these days in owning a UK property via your BVI company. Plenty of people have BVI companies to hold assets. There's various advantages in having companies and trust structures in those types of countries. And so no, it's not that it's a no-no at all.
So if you had just one will, say in my case in Australia, that covered assets both in Australia and in Thailand, that should be accepted by the Thai government?
Yeah.
Or in Thailand? You don't need to do 2 wills.
Don't need to. It's not a legal requirement. Not a legal requirement. We're quite clear in our introductory information that we send to people. We say it's not a legal requirement to have country-specific wills. But for all of the reason we've sort of touched on today, there's a number of benefits in doing it in that
But
way.
would it be recommended, therefore, to have 2 wills and therefore make this will the last testament for Australian assets and this one the last testament for Thai assets? Would it be recommended to do that, or just have one for both?
Recommended to have separate wills. So if somebody's just got a bank account and some household effects in Thailand, it probably doesn't warrant a separate will. But when you've got property and bank accounts and investments, probate, that process of probate would be required. And if you think it's going to take 6 months in each country, if you die, if you've got a Thai will and an Australian will, I'm your executor, I do probate in Australia and Thailand at the same time with 2 different wills. If you have one will, I'm going to do probate in Australia, and that's going to take 6 months maybe. When I've done that, I then bring the will to Thailand and go through the process to get that will authenticated and accepted by the Thai authorities. In the meantime, your assets in Australia can't be accessed, paid out or distributed. They're still stuck in probate because probate is not complete. So another 6 months in Thailand for your will to be examined and checked and have certified translations and various affidavits, and then to deal with the Thai estate, pay off the taxes, deal with everything. Another 6 months, your executors are fed up and there's legal fees incurred by all of this back and forth. Eventually, yes, your estate will be sorted out and dealt with.
It's better to have 2 wills, but one for Australian assets, one for Thai assets.
Yeah.
But you just mentioned that you would have to have translations. Earlier you said the Thais would accept an English language will.
Yes.
But then just now you said you'd have to probably get it translated into Thai.
Right.
So is it worth writing? I'm keeping track.
Yeah.
Is it worth writing it in Thai in the first place in Thailand?
Yeah, good question. Yes and no. In most countries, a will, for it to be valid, has to be in a language that you understand, the person making the will. So when you get somebody, we get people with assets in China and Thailand and Indonesia, when you're making a will for that country, I think we'd always say to our clients, we can do the will, but you might want to go to the local solicitor or notary in that place to do the will for you. If not, we have a lot of people who write the will, we do a will for China, and they will have a certified translation of the will prepared in the safe, together with the original, just to save the executors some time.
Okay.
So it's not legally required, but it's probably a good idea if you're organised to have that prepared in advance.
But also you have to be careful when you get the legalized or going to be executed in the same time as well, because on the date when you execute it exactly. Basically, let me example. If under Thai law, when you do the succession proceeding in Thailand, you have the other jurisdiction will, and then you want to use that will to Thailand. You just get the translation in Thailand and submit to Thai court when you submit the succession proceeding in Thailand.
Yeah, there's a whole number of formalities for the probate that you're talking about there, here and for different places. So when there's just a will in Australia that's got to be accepted in Thailand, when there's a will from the US that's got to be accepted here, there's various formalities that need to be gone through, as you might imagine. So,
Is there any time limit for applying for probate, or in case of intestate, any time limit after that?
I seem to think it's 2 years, but I'm not 100% sure. It's not something that has to be done a week after somebody dies. We had a client call up the other day, and their husband had died 4 months ago, and they'd had no need to get the will and to sort things out for whatever reason. So they eventually get the will, they'll eventually go through this process of tidying up the estate, closing down the bank accounts, but there was no great rush for them. I'm not exactly sure, and again, it's probably country by country what the requirements are.
So in case the time limit is lapsed, what's the process then?
If time limit has lapsed and no one, well, I mean, if no one's submitted a will, normally, you know, somebody dies and it doesn't normally go on for 2 or 3 years, does it? Somebody would come forward, the beneficiaries, to say we're entitled to the estate, and then if there's no will, it has to be shown that all reasonable efforts have been made to find a will. And if there's no will, then you can go to the intestacy procedures. But I seem to think it's 2 years, but I wouldn't hold it to that.
Do courts only want pieces of paper, or can you actually get a will witnessed and signed and then scan it and throw the piece of paper away? Can you use the electronic version in a court?
Good question. A lot of people ask that. The courts are still quite old-fashioned with wills. They want to see the original signed and witnessed and dated original document. There's been a couple of cases, Australia was one, where somebody had sort of typed out their will on a mobile phone and committed suicide, and this was accepted by the courts as being sufficient to show their intention. The only other time when a copy of a will is accepted is, we store wills in our safe, for example. If the safe burns down, it's fireproof, I don't know how long. If the safe burns down, you die the next day, the company that produced the will can provide a certified copy, because the original has been damaged or destroyed, that would be accepted by the courts. But otherwise, the original needs to be produced.
But digitally signed contracts are acceptable now, so why would a will not be?
Just the formalities. Wills are different to contracts. The probate courts are very strict in most places. They need the original signed, dated wills.
Is it probate compulsory in Thailand? Because in some state, New South Wales, it's compulsory, in Queensland it's not.
I think it depends on the value of the estate. In some countries...
And who's in the will?
Well, my understanding, I'm just thinking of an example in the UK. If an estate in the UK is below £10,000, formal probate is not required. You can produce the will at the bank and they're normally happy to release the assets. So I think it's more on the value of the estate rather than the distribution of the assets.
I'm an Australian citizen with indefinite leave to remain in the UK, but domiciled in Thailand, but I have a property in London. how would I protect that the best way?
So,
You don't have a UK passport. You don't have a UK passport. So it's unlikely that you're going to be deemed to be UK domiciled when you die, unless you spend a long time living there. So if you've got a property in the UK that's above the tax-free allowance, there's not a great deal these days that you can do to protect against that, other than to start to think about gifting it while you're alive. You might investigate the use of a trust, but again, they're really clamping down on foreign ownership of any type of UK assets. Otherwise, sell it, move the money to a country where there's no tax. I guess it's the simple answer.
Can I quickly step in at that moment and formally close the meeting? And can we first of all express our great gratitude to Matthew for his I think the Spanish Inquisition is difficult. I think all of you have really put Matthew through the hoops and given the fullest possible answers that he's had to those questions. So Matthew, thank you very much for your fascinating and very interesting presentation this evening. If I can possibly emphasise one point, the most important thing is to get good advice. If you really think that, you can talk to your friend in the pub and your friend in the pub knows how to draft a will, okay, the more fool you. The important thing about drafting a will, and particularly in these situations that we've discussed, where there's mental or physical incapacity during someone's lifetime, and many of us will end up suffering with some form of mental incapacity before we pass on. You've got to think about what to do in that situation as well. So thank you very, very much, Matthew. And I think, provided that Matthew's available, I'm sure he'll be able to talk to you about particular matters if you'd like to talk to him further. Thank you very much.
So asking.
yes.